Thank you for joining us for this webinar. Your teen just turned 18, Guardianship, Medicaid, and SSI. This webinar is being offered by the Autism Society of North Carolina. I'm Nancy Nestor, one of the Autism Resource Specialists from the Charlotte office. I'm also the parent of a 21-year-old son with autism, so the information that I'm about to share has been part of my life for the past few years. This webinar is being presented for informational purposes. Autism resource specialists are not attorneys. This presentation is intended to give families the information they need to aid in their decision of making the best future for their child. Remember, each person with autism is unique, and there is no one-size-fits-all answer. If you have more in-depth questions, we suggest you seek the advice of an attorney for your particular family situation. If you're not sure of where to turn to find an attorney, you can reach out to the Autism Resource Specialist in your area in order to find someone. So let's go over the objectives for our presentation. First, we're going to identify your son or daughter's needs. We're going to determine whether guardianship is appropriate for your family. We're going to learn about Medicaid for adults with disabilities, as well as SSI for adults with disabilities. And I'm going to help you find out what to do in the case of a denial. So let's think about your child. Your child has grown up, and you now have an adult disabled child. So it's time to make appropriate supports, make sure they're in place for him or her to live a life that's as safe and independent as possible. As your child with special needs becomes a grown-up, we're faced with new and sometimes difficult issues that we have to face head-on. As hard and as emotional as it can be, we must give our children our best effort in planning for their future and making those difficult decisions for their benefit. It's time to question what's necessary and appropriate, not what's easier or better for us as parents. Usually, parents start thinking about guardianship when their child with special needs turns 18. The guardianship process can actually start as early as 17 and a half. When a child turns 18, the age of majority, no matter their developmental or functional level, they're considered an adult and assumed competent. The parents are no longer recognized by law as the decision maker when it comes to their child's education, healthcare, or financial affairs. So under the law, adults are presumed to be competent with all the rights and responsibilities of adulthood. Adults who cannot take care of themselves or make or communicate decisions in their best interest or handle their assets may need some protection. But guardianship should not be an automatic decision. We need to consider the strengths, weaknesses, needs, and best interests of an individual. However, there is a task that must be done no matter. For young men, many parents do not realize that the registration for military is a must. Once your child turns 18, he'll receive a notice in the mail from Selective Service for the military. Almost all citizens and male immigrants who are 18 to 25 are required to register. Men with disabilities who live at home must register with Selective Service if they can reasonably leave their home and move about the community independently. A friend or relative can help the person with disabilities fill out the registration form if he can't do it himself. So those with disabilities that would disqualify them for military service have to register for Selective Service. Selective Service doesn't have the authority to classify men, so even men with obvious handicaps must register now, and if needed, classification will be determined later. If you need more information about this, you can go to the Selective Service website, which is www.sss.gov. So let's think about your child. Depending on your child's situation, you'll have a variety of options and supports to help them transfer into adulthood. So think about when your child will leave high school. Will they leave when they graduate with a regular diploma? Or will they leave when they graduate with an occupational course of study diploma, which is sometimes at the age of 18 or 19, but sometimes later? Will they leave when they turn 22 with the certificate of attendance? In all these situations, the transition to adulthood is going to look differently. Does your teen currently have the innovations waiver? If he does, or she, then supports will already be in place to help you with that transition into adulthood. Has your teen been involved with vocational rehabilitation? If so, again, that's another support that would be in place to help. And lastly, let's talk about guardianship. Is it appropriate for your son or daughter? And if not, what other supports are in place? In North Carolina, there's 4 situations which are considered when we think about guardianship. The first situation is often one that we think about with our own kids. Minors approaching the age of 18 who are not capable for taking care of themselves. They can't make or communicate important decisions or manage their financial assets. Those kind of people may need a guardian. Reasonably, any minor who inherits property would need a guardian to manage that property until they become an adult. A third case is a minor who lost their parents through death. They will need a guardian to make personal decisions for them. And lastly, guardianship is often given to someone when an adult becomes incompetent through disability, injury, illness, or disease. And they need a guardian to make personal, healthcare, end of life, or property decisions. But you must know in North Carolina, the whole decision-making process doesn't have to be optimal or perfect. Someone does not have to be able to make perfect, reasonable decisions. But a judicial determination of incapacity requires proof that the respondent's decision-making capacity is significantly impaired. So there has to be proof that that person is not able to care for themselves, and that lack of being able to care must be a significant deficit. So what is a guardian? A guardian is a person who helps exercise the rights of another person by managing their finances, their property, health care, and personal affairs. They make all of the major decisions, and they must act in the best interest of the ward. The term ward refers to the person who has someone else serve as their guardian. The guardian should offer the ward freedom if the ward is making good decisions, but they can veto or override any poor decisions that the ward is making. Remember, guardianship is an extreme form of intervention into another person's life, and because it controls the personal and financial decisions, and it transfers that power to someone else for an indefinite and often permanent period of time. Once it's established, guardianship can be revoked. Therefore, guardianship should only be used as a last resort because it is difficult to overturn guardianship. Let's talk a little bit about the duties of a guardian. A guardian can make decisions in the areas that are authorized by the court and only in those areas. The guardian must act in best interest of the ward, including the ward's possession of money or possessions. They have to offer the ward the opportunity to participate as much as possible in the decisions affecting them. Guardianship is not a dictatorship, but a limited partnership at times. You have to think about the needs of your child when you determine guardianship. Some of our children will need a guardian to make all of the decisions for them, whereas others may not. Think of your child and try to make the best choice that will allow them to retain as much freedom as possible while keeping them safe. Guardianship can change over time. It can become more or less restrictive as needed. And anyone who is a guardian must complete regular status reports to the clerk of court. And generally, these reports are annual. And I will be talking about this a little bit more when I talk about the different kinds of guardianship. Many places, joint guardianship is allowed. It means that both of the guardians must agree and act. It doesn't mean that either one or the other can act alone. A request for joint guardianship may be prompted by the concern about who will become the guardian if the guardian dies, such as in the case of a parent that may have a chronic or terminal illness. Parents who are guardians may select a successor guardian, and they do that in their will. You should know that in certain counties in North Carolina, such as Mecklenburg, only one parent can be named as a guardian. So before you go to get guardianship of your child, you need to find out what is the status in your county, because families who live in a county where there's no joint guardianship will need to do some planning ahead of time. And for those who do allow joint guardianship, both guardians should decide what guardianship will look like and how the decisions will be made before you go to court for guardianship. So let's talk about the different kinds of guardianship. First of all, there's guardianship of the person. That person has the authority to make decisions in most areas of the ward's life, day-to-day decisions, things like perhaps maybe they were where they live, or the kind of bedspread they have on their bed, or where they will go to get their hair cut. They'll make sure that the ward receives proper care, ranging for education, medical care, if they need help with jobs or transportation. Whether or not they will work, they're going to give consent for needed services like dental, medical, psychological, and they're going to take care of the ward's belongings, taking legal action to protect the ward if necessary. It doesn't mean that you have any authority to make decisions regarding financial matters like money or property. The authority is only about the care, custody, and control of the ward. Under certain conditions, an out-of-state resident may be appointed the guardian of the person. And there's no bond or accounting if you are the guardian of the person. Another kind of guardianship is guardianship of the estate. With guardianship of the estate, the person does not have the authority to make any decisions regarding personal care. They only have authority for managing property, someone's estate, and business affairs, like managing funds, paying bills, selling assets, investing, making repairs to the home, collecting benefits. And the next kind of guardianship, general guardianship, and guardianship of the estate, the guardian has to file annual financial statements. They have to have a current inventory of assets. They have to list all of the income. A year later, they have to give an annual accounting. There's an online form to fill out, starting with the balance on the inventory. They have to keep copies of all check stubs and submit them for the year, as well as original receipts. We advise that you don't use a debit card because checks are easier to track, and you're not able to show bank statements when you make your accounting. Also know that to be a guardian of the estate or a general guardian, you have to be a resident of North Carolina if the person that you're guardian over lives in North Carolina. And also know that the Department of Social Services does not manage property, estates, business affairs of wards that are appointed guardian of the state to fulfill these. So if you have a situation like that, the court will find someone else to be the guardian of the estate to fill the duties, because DSS will not do that. For most of our children, a general guardianship is what you will be asking for. The individual or agency acts in combination, a combination of both guardian of the person and guardian of the estate. They're going to have the authority to make all decisions for the ward. They have to be bonded through the court, and they have to account every year in a filing for the money and property of the person. And you must be a resident of North Carolina. So these reports that you would make are very similar to the reports that someone would make on a descendant's estate when someone dies. You have to fill out a letter of inventory within 90 days of the issuance of the letters of guardianship, and then on the annual anniversary of the issuance of the letters, you have to go ahead and fill out the paperwork and turn it in. There's never a need for a filing for motion of extension of time to complete the administration, because guardianship of estate and guardianship of a person last until either the estate runs out of money or the ward passes away, or until the ward's competency is reinstated. There is a situation where sometimes an intermediate guardian might be needed. So in the case of interim guardian, a guardian is temporarily appointed prior to the adjudication of incompetence when a situation requires an immediate intervention to address imminent danger, which is danger that is certain to happen in the person's well-being or to the person's estate. So in a situation where someone with a disability, the guardian is taking advantage of them, either physically or abusing their property, then someone else can file for intermediate guardianship, and a judge would be involved in this situation. It would be considered a legal situation, and court would occur, and they would take guardianship away from the current guardian and give it to someone else. So temporary guardianship for minors would also occur whenever someone needs legal guardianship to make sure that their health, education, recreation, and other decisions are being used and appropriately. So limited guardianship, it's an alternative avenue to protect those who need some assistance but who are capable of managing certain areas of their lives. It recognizes and appreciates that individuals with disabilities have different abilities in different areas. So by restricting the powers to a given guardian, the limited guardianship promotes self-determination and autonomy by tailoring the guardianship to allow retention of certain decision-making authorities, not reposed to the guardian. So what this does, and I hope if possible that many people think of this when you go for general guardianship, think about whatever your child can do, whatever they're doing that they're capable of doing, and write that into the guardianship, because it's important to preserve as many rights as possible. So in a situation like this, the guardian's authority is limited. The parent or the guardian agrees to give up some of the choices to allow the ward to retain some choices in respect to certain areas. So perhaps if you have a child who is responsible and good with money, then you might allow them to have some banking and monetary privileges. If they have shown that they are able to drive a car responsibly, you may put in the limited guardianship that they would be able to have a driver's license. So let's talk about whether or not guardianship is appropriate. It's difficult to make that decision because disability is not the same as incompetence, although when you file for guardianship, you are declaring the ward incompetent. So those seeking guardianship have to fill out a form that'll be shared with the court-appointed personnel. you may have 2 or 3 other people respond to this form, and if possible, get information from your child as well. And the forms are available at this website, www.nccourts.org. You're going to click on Forms. You're going to search for AOC-SP-200, which is called the Petition for Adjudication of Incompetence, an application for the appointment of guardianship or limited guardianship. And that's how you start the process. To help with the guardianship decision, you want to use the Guardianship Capacity Questionnaire, which is that AOC SP 208 form. And even if you're not sure whether or not guardianship is appropriate for your child, it's important to go ahead and look at that form, because it will help you make the decision whether or not you should have guardianship of your child, and if so, what level of guardianship is important for your child's safety as well as for their freedom. So when we look at the guardianship capacity form, it looks at things like your child's ability to use language and to communicate independently. Can they take care of their nutritional needs without any help? Do they maintain good hygiene and health? Are they able to stay safe? Can they live by themselves, or can they live in a group? Because some of our children would really struggle to live in a group. Are they able to seek and maintain employment? Can they handle their finances? And are they capable of self-advocacy? Please remember that guardianship is a life-altering experience, because if you get guardianship, you take away from the individual their ability to make decisions. The person is being declared incompetent. And many of the freedoms that are needed to build an independent life are altered so that the ward can live safety. But the sad thing is that when you take away these opportunities, it makes it difficult for them to develop the skills that they need to live on their own successfully. So it's kind of a balancing act. Remember that guardianship is reversible, but it's a long process, and it requires a lot of documentation and some money, because what you will have to do is go to court and prove through data that every point which was used to declare the person incompetent no longer exists. So let's talk for a minute about the guardianship process. The first thing you would do is you fill out an application form from the website, which I just gave you, or you can go to the clerk of court's office and ask for an application for incompetency. You fill out that application, you get all the information that's needed, and you return it to the courthouse, either by mail or by hand. A guardian ad litem will be appointed, and the guardian ad litem will come to your house and meet with you and your child. It's usually within a month of the application being returned. After that meeting takes place, within a few weeks, a sheriff will serve a copy of the guardianship petition to your child, which gives the date and time for you to take your child, possibly, and go to court. If you're unable to download the form, you can go to the clerk of court's office in your county, which is usually located in the courthouse, and request the paperwork for guardianship for a disabled young adult. You can start the process within 6 months of your child's birthday. You need to know that if you don't start the process within the child's 18th birthday, that it's okay. Many people often don't even realize they need to file for guardianship for their child. So whenever you're able to start this process, you can. The court will require that you provide some information, such as the stating of a current diagnosis, school records that show that your child's been served in special education for years, their latest IEP, a recent psychological, possibly an adaptive rating scale such as a Vineland, because incompetence is based on medical and psychological evidence. A guardian ad litem will be assigned to come and meet with your child. A guardian ad litem is an attorney who's especially trained. They're appointed by the court. They represent your child's best interest. So they will meet with your child to determine their feelings about having you as their guardian. They will meet with you and your child, usually in your home, and then at the hearing of incompetency, they will appear and make their recommendations. You will not have to pay the guardian ad litem. They are paid by the state of North Carolina. Another part for guardianship, which sometimes is very frightening for our children, is a meeting with the sheriff. North Carolina law requires that the sheriff personally serve a copy of the petition to the child, which means they can't hand the petition to you or give it to a neighbor. They have to hand it to the child. If your child is fearful of law enforcement, many sheriff's office will work with you to make it less stressful. I've heard of people calling the sheriff's office and coming for a tour, and as part of the tour, they hand the child the petition. I've heard of parents meeting the sheriff at the ice cream shop, and the parent is eating ice cream, and the sheriff just stops by the table, hands the child their petition, and goes on his way. So you may talk to the sheriff prior to them visiting your home. And it's also a good idea when the guardian ad litem comes to visit, if you think that the sheriff's delivery is going to be concerning or upsetting to your child, mention it to the guardian ad litem and he may be able to help. The same is true for the hearing. The child may attend, but he doesn't have to. For many of our children, going in public can be very stressful. And some of our courthouses, especially in big cities like Charlotte, that would be an impossible task. So if you know that it would be too stressful for your child to go downtown with all the traffic, with all the noise, to go through a metal detector, to go up echoey stairways into a big room full of people, you may ask the guardian ad litem to check and make sure that it's okay that your child not come to court. For an uncontested hearing, the hearing is going to take place in a conference room rather than in a courtroom. However, if your child contests their incompetency, the hearing will be more intense and more structured so that your child has time to defend themselves legally. The guardian ad litem will report, and you are also allowed to bring someone with you who's able to talk about your child. It could be your spouse, a close relative, a longtime friend, a minister, someone who knows your child. You need to know, though, that that person may or may not be asked to speak. So if you'd like them to come just for moral support, they can do that. But they should know they may not be able to speak unless the magistrate asks them questions or invites comments from them. So then, after the hearing or at the end of the hearing, the guardian will be appointed and paperwork will be filed. The guardian will go next door to the clerk of court with the magistrate, and official papers are signed. You'll need to pay court fees at that time, and according to the North Carolina website, the magistrate's website, the cost can range from anywhere from $150 to $200. You want to check with your clerk of court about the prices for services, and you're going to look in the special proceedings court costs section of your court system. For some courts, if you don't have the money to get guardianship of your child, there are different funds available, but not all courts have this. So what you may have to do is find a way to save the money if that's an issue for you, because you have to be able to pay the court fees in order to get the guardianship taken care of. And I know for some families, they've not been able to afford to do it when their child is 18. You know, for some of them, it may take a year or maybe 2 in order to save the money to go get guardianship. So let's talk a little bit about the discussion of incompetence. Incompetence means lacking sufficient capacity to manage one's own affairs or to make or communicate important decisions concerning one's personal, family, or property. So all adults are presumed competent. We all have the freedom to make bad decisions. And remember that incompetence in one area does not mean incompetence in all areas. But also remember that a disability does not mean incompetence. So when we're developing guardianship, we want to try to preserve as much independence as possible. So with limited guardianship, the ward has the freedom to choose many things. They may be able to choose where they live, in a group home, an AFL home, in their own home, or with the family they grew up with. They may also be able to choose where they worship or where they get their haircut, or being able to go to a certain movie theater once a month to watch a movie. All of these things are very important when we decide about guardianship. But there are some rights that are lost when an adult is declared incompetent. Of course, being declared incompetent means that you lose some of your self-determination. There are some decisions you're no longer able to make. Also, you're not able to serve on a jury, because being part of a jury requires one to be able to determine the facts based on limited evidence and the actions of those who are testifying. People with autism often have a hard time reading the behaviors of others, so developing an accurate view of a witness may be too challenging for them. So it might be reasonable that they would not be allowed to serve on a jury. Another thing that many people don't realize is when an adult is declared incompetent, the Department of Motor Vehicles may deny the privilege of driving. In fact, part of the process when someone is declared incompetent is that the magistrate contact the DMV to let them know a person has been declared incompetent. And unless the judge has decided to spare that person's license, their ability to drive is taken away from them. But there are cases where students in regular or OCS classes and have a good track record of perhaps already having their license and not having any accidents will be able to retain the right to drive because parents have asked that the license be spared and there was academic, practical proof and medical proof to support them continuing to drive. So once someone has their guardianship rights taken away, they still retain some rights. They have the right to vote. They can enter into a contract or marry if there's sufficient capacity to understand the nature and consequences. They have the right to make a will, presumed that they are competent enough to make a will. And as I said earlier, the right to drive is determined by the DMV, but it's based on the facts of what is presented at the incompetency hearing. They have the right to be a witness if they're able to understand an oath, if they're able to tell the truth and understand truth and consequences, if they have the ability to observe, remember, and relate what happened. So let's talk a little bit about what a guardian has to do. Did you know that a guardian is not required to financially support the ward? And they're not required to live in the same household as the ward. They're not liable for the ward's debts, and they're not responsible for any illegal actions the ward may commit. However, if the guardian fails to fulfill their duty to the ward, it's considered negligent. And if this leads to the ward's destructive or damaging behaviors or activities, then the guardian can be held responsible in court. So there's a delicate balance here. as long as you're trying to keep the ward safe, then that's fine. But if you're negligent in allowing the ward to do illegal things and unsafe things, then you may be taken to court. Can guardianship be reversed? Yes, it can be. It can be modified to add rights. It can restrict certain rights, and you can change the type of guardianship. All of this has to be done by going to court, but it doesn't change who is the guardian. The person who is the guardian and removal of the guardian is always because of a situation of someone not protecting the ward's interest. So it would require the guardian to either resign or to have a formal motion to remove the person for the case. So it again would require someone going to court and proving through court that they are not able to be the guardian from that point on. Another option is the restoring of competency, as I talked about earlier. Restoring competency is possible, and the ward themselves can petition the court at any time to ask that their competency be restored. It is a long process, though, and they have to prove that they are competent and that they are able to take care of themselves. All of this is done through a motion to modify form that's filed through the court's estate division. And I will tell you that some clerk of courts are hesitant to reinstate someone's competency. So that's why it's really important to think about it before you go ahead and do competency. Well, let's say that guardianship maybe is not appropriate for your child. There are several options that you can think about. If you feel that guardianship in any form is too limiting and will restrict your child's ability to develop to full potential, you can consider these options that are listed. Many of these can be accomplished without the expense of an attorney. Power of attorneys can be downloaded from Disability Rights North Carolina websites, or you can go to some stores like Office Depot or the UPS store. Power of attorneys have to be notarized with the child present. They have to agree to allow you to give them help in situations that relate to property, healthcare, even education. And know that banks will not typically notarize a power of attorney in a situation like this. So if you know someone who is a notary that also knows your child, it's a lot easier to get these forms filled out and notarized. Other options are a joint bank account, automatic deposits, a permanent withdrawal rider, and making yourself the representative payee from any fundings that they get. All of these allow you to maintain control over your child's finances while you help them learn more about managing their money. Some families will have a debit card in an account, a joint account with their child, and they'll have a limited amount of money in that account, such as maybe $200. So that once the money runs out, then the child has to work in order to come up with a plan to keep the right amount of money in there. The other thing I want to talk about too is with a power of attorney, your child has to understand and support your need to help them, because at any time your child can cancel that POA. So you have to consider their ability to understand their own limitations. And if they understand that you are there to help them, then they're less likely to allow someone to talk them into canceling the POA. You can also have an appointment of an advocate and authorization. And the authorization would happen such as in a college setting or getting services through a provider or vocational rehab. Your child can ask that you be provided a release of information so that they are formally giving you permission to advocate for them. In cases like that, then schools or service providers or voc rehab or jobs have to listen to your input. And of course, another very good way to take care of your child's future is through the use of a special needs trust. Let's move on and talk a little bit about Medicaid. So unless your minor child has the Innovations Waiver, which provides for supports through IDD, mental health, or substance abuse by waiving a parent income, they may not be able to attain Medicaid before adulthood. And the reason why is because in North Carolina, the health insurance program is for low-income individuals, citizens, seniors, and people with disabilities. So until your child is an adult, their income is based on the family income. So it only provides for medical need. So there are two kinds of Medicaid. Medicaid for disabled workers and Medicaid for long-term care. And in order to get Medicaid started, you would contact your local Department of Social Services to apply. So let's take a little bit more time to talk about Medicaid because it's very confusing. So I know there's a lot of information on this slide. I'm going to talk about it a little bit and then kind of review and summarize. So the basics of Medicaid is that it's a federal program and it's designed to assist low-income individuals to get the health care services by matching state funds with federal funds for approved health care services. To qualify, the person has to meet income and asset criteria, which has a certain fit and categorical requirement, such as being on the Temporary Assistance for Needy Families program, a low-income program for pregnant women, the disabled, or children from a low-income family. For most adults, especially those without children, they do not qualify for Medicaid. Some changes occurred in 2014, and that allowed some more flexibility. Medicaid classifies services and populations into optimal and mandatory. The federal government requires that states cover limited populations with limited services. For example, low-income pregnant women can get coverage for prenatal care, childbirth, and children in foster care can get some coverage. These are mandatory populations and mandatory services. In addition, they allow states to cover optional populations. An optional population service, it has the same matching formula. Every state chooses to deliver the service to, in that every state decides who to deliver the services to and what kind of services every state plan and program is different. The federal government, through the Center for Medicare and Medicaid Services, CMS, approves those plans for states. However, it will provide services. The state will. Medicaid covers health services and supports that are medically necessary. It doesn't, however, cover room and board in facilities, transportation to school, or other related supports. So once a plan is approved, the populations identified under the plan are usually entitled to services outlined in the plan. One of the reasons states struggle with Medicaid budgets in difficult economic times is there's more low-income people that are entitled to health care. To confuse things a little more, some programs under Medicaid, such as waivers, are not an entitlement. A limited number of people can receive a waiver, and not everyone is eligible for services. So states, in conjunction with the federal government, determine who and how many will be served. When slots are full, they don't open more to serve all the people that are qualified. And all the services for treatment and support of people with mental health, developmental delays, and substance abuse are considered optional. an optional Medicaid for all of those populations, but there are some exceptions, such as a pregnant drug user, children under the early periodic screening, diagnosis, and treatment plan. Although enforcing services for kids under EPSD seems to be a little easier than it was in the past. Other options are dental, orthopedic, and vision. In North Carolina, legislators often talk about eliminating optional services because they're not required to do them by the federal government. Yet they have done so as other states. Some advocates regularly make the argument that Medicaid services are great options because people stay in the community or at home and it costs less than sending someone to an institutional setting. And that doesn't change the fact that the federal government doesn't require states to often offer these options. So let's kind of review it again. So Medicaid is a federally funded program and it's matched with state funds. The traditional Medicaid is for low-income families and adults with disabilities. It covers doctor's visits, emergency rooms, and medication. It might cover, or it does also cover, a placement in an intermediate care facility or other long-term care, such as personal care, adult care, and nursing care for someone who is severely disabled. There are also enhanced services, such as mental health and addiction services and supports. Also B3 services, which is for people of low income so that they can get important services that they need. There's early periodic screening, diagnosis, and treatment, which is catch-all funding for children. And here in North Carolina, many families who have children under the age of 21 can use this EPSDT funding to pay for ABA treatment. There's also Medicaid home and community-based waivers, such as the Innovations Waiver and other CAP programs for children and disabled adults. So how do you get these services? Well, today we're talking about Medicaid for disabled adults. So you're going to go to http://www.dma.ncdhhs.gov Medicaid and click on Get Started. If you have guardianship of your adult child and your child's been receiving the Innovations Waiver, you can contact DSS and ask for help on how to apply for Medicaid for your disabled adult child. If you have a community guide or a community navigator, they should help you learn to apply, or they should help you apply. If your child does not have services, you'll need to contact DSS to apply for Medicaid. Once your child has Medicaid, you can contact your local MCO and ask for B3 services such as respite or community guide or job coach. You can also ask for other adult services such as adult cab. So you're going to go to the website, you're going to learn whether or not you're eligible for Medicaid or Health Choice. You're going to apply, you're going to find the programs and services that are right for you, and then choose a doctor or medical home, and you're going to look for an ID in the mail. This is if you don't have Medicaid to begin with, or if your child was not part of the waiver program. So how do you get started with this program? Well, you go to NC Fast Start, which is listed in the website below, and you click on Apply Now. Your County Division of Social Services caseworker will help you find the Medicaid programs that fit your personal situation. So just go to that website. You can apply through the computer, or if you need help, you can go to your county DSS. Again, if your child already has the Innovations Waiver, your community guide or your care coordinator will help you make that crosswalk transition between child services to adult services. If you have a child with a disability, Medicaid may be available to you if you are, or your child is blind or disabled, or your income or resources are under a certain limit. There's also health care coverages for workers with disabilities, and it provides for individuals ages 16 to 64 who have a disability with the opportunity to work and still receive Medicaid. So if your child is able to work, it's very important that they do work so that they can start building up some benefits. If in the future they're not able to work for one reason or another, they can start drawing for that Medicaid for Disabled Workers fund. If your child has a disability, you can also look at community alternative programs, and they help our young people receive long-term care services in their home rather than having to move to a nursing home or an AFL home or group home. Another possibility is CAP choice, and that allows adults more control over the types of services they receive, when and where they're provided, and who provides the services. And these are available under the CAP Disability A program. There's also something called money follows the person. So if a person has been placed in a residential program away from the community, then money follows the person funding helps them transition back into their home community. And with MCOs, this program is called Community Transitions for individuals who are not currently getting the innovations waiver, but rather have B3 funding because of their low income. So just know if you have a loved one who is placed out of the community for one reason or another, these fundings can help them move back to their community so that they can have life closer to their family and more interaction. Know that Medicaid and SSI go hand in hand. In some of the larger counties, it's easier to apply for SSI than it is to get Medicaid. If this isn't the case in your county, you may want to apply for SSI first. Once your child has SSI, you can notify DSS and they'll send you a Medicaid card as well. With Medicaid, disabled adults can begin to access B3 services through the Innovations Program, which gives them respite, a community navigator, and supported employment. So remember, once your child becomes an adult, the ability to get assistance is based on their income. So they may qualify for Medicaid because they're not able to have a job. And if they are able to have a job, their income may be well below the poverty line, which would allow them to qualify for both Medicaid and SSI. If your child has extreme needs, they may qualify to receive more intensive services through the CAP program, which was on the previous slide that said, what is Medicaid? Your managed care organization is the portal to getting all of these services. So you may not even know what is your MCO. If you don't know which MCO organization serves your area, you can go to the DHHS website and you can find the contact information. Basically, if you live in the western part of North Carolina, your MCO is VIA. If you live in the western Piedmont area, near Morganton or Hickory or Taylorsville, Cleveland County, Lincoln, Iredell, then Partners Behavioral Health is your MCO. If you live the central part of North Carolina, from Charlotte up through Greensboro and north, then Cardinal Innovations Healthcare is your healthcare MCO. Southern Piedmont, that would be the area close to Fayetteville. Then you would be in Sandhills. If you live in the Raleigh area, then Alliance Behavioral Health Care is your MCO. If you live in the southwestern coastal area, then East Point is your MCO. And if you live in any county that touches the ocean, as well as a couple that are inland, then Trillium Health Solution Resource is your MCO. If you're not sure that you've ever heard of any of these companies, then you can go to the North Carolina Department of Health and Human Resources website, and it will tell you which of the companies serves your county. Let's talk a little bit about Social Security. So Social Security and Supplemental Security Income disability programs are the largest of several federal programs that provide assistance to people with disabilities. Only individuals who have a disability which has been documented to occur before the age of 22 and meet certain medical criteria can qualify under these programs. This is why it's so important, if you are not sure whether or not your child has a disability, that you go ahead and get that medical diagnosis before they turn 22. Because once they turn 22, it's extremely difficult to get help for them through SSI, especially for those who are not able to work. So how do you do this? Well, if you go to the SSI.gov disability website, you'll see that there's two kinds of SSI. There's Social Security disability insurance, which pays benefits for persons with disabilities and certain family members if insured. And then there's Supplemental Security Income. It's designed to help people with disabilities who have little or no income. It provides cash to meet their basic needs for food, clothing, and shelter. And it's helpful for people without a work history so that they can they might not qualify as children. Some people with autism would qualify for this as an adult. So let's look at it a little closer. For adults, Social Security, it considers the individual's income, including their wages, bills for food and shelter paid by someone else. It includes the Medicaid they receive. And once it's approved, their total in resources, which would be income and savings, cannot exceed $2,000. And they would receive a monthly payment based on their income. Now for children, this SSI is based on the parent's income and assets, and it also includes Medicaid. So understand again that if you have a child who does not qualify for Medicaid, once they become an adult, because they're not able to earn enough money and they have a disability, they may qualify for SSI. But once they do, they can't have any resources that exceed $2,000. So how do you apply? Well, if you have guardianship of your child, you can complete an online application. You also can call SSA toll-free at 1-800-772-1213. Then you'll make an appointment with your local Social Security office and you'll fill out paperwork in person. If you're helping someone else apply, you can refer to this website on the Social Security website. So you'll be asked to supply some information about your child's medical, educational, work history, so that the examiner can determine whether or not the adult child meets the criteria. This is pretty much the same information that you would need in order to apply for guardianship, or if you were applying for the innovations waiver. You need to know that you're going to be asked to submit original documents rather than copies or certified copies. So you need to be sure you need to ask what kind of copy you'll need before you go to your appointment. And also know this process can take 3 to 5 months, so you need to be prepared for that wait. So what can you do if your teen is denied in Medicaid or SSI? You need to know that getting denied is very typical for all applicants with disabilities. So just don't think that it is your particular child. It happens to everyone. So when you receive your letter of denial, you'll receive instructions for appeal. You need to follow those appeal process timeline and procedures and find out whether or not additional information is needed, because very often a denial occurs because some key information is missing. Then you reapply for services. Sometimes it takes time to prove that someone with a moderate disability, it could prevent them from being able to maintain employment or live independently. So it's very possible that at the age of 21 or 22, your child may be denied their SSI. But by the time they're 30, it may be a lot more obvious that they are not able to maintain employment or live independently because of their disability. So sometimes with someone who has a moderate disability, it just may take more time to get the supports that they need. So there are also some responsibilities that go along with SSI. Just like with guardianship, specific records have to be kept to show how the money is spent. If your adult child gets services through an MCO, they will help you with the spending documentation, but you're going to need to keep track of all the expenses as well. And at some point, your child's SSI or Medicaid may be questioned, so be sure that you keep good records. I think I mentioned before, you want to try to use checks because it's easier to trace how money is spent and prove how money is spent if you use checks. And also keep good copies of original receipts for every money all the money that's spent on your child. Transitions are always a challenge, and this is another transition in your child's life and in your life. So at first, the new responsibilities may be a challenge. Use online resources and the MCO support designed to help you. If your adult child does not have a community guide or community navigator, make sure you get one. Not all consumers qualify for one, but it's worth your inquiring because many times they do. And community guides help families, many families, with these sorts of situations. So they're a great resource. If you have difficulties, please reach out to the Autism Society Autism Resource Specialist in your area. And if you're not sure who that person is, you can go to the Autism Society's website, www.autismsociety-nc.org, and click on Get Help, and you should be able to figure out who the Autism Resource Specialist is for your part of the state. Here are some other resources that you'll find helpful. The Disability Rights website has all sorts of information on powers of attorney and guardianship and how to advocate for your disabled adult should they have issues either just in life or through their work. The North Carolina court systems will have all of the court documents that you'll need to look at when you're considering guardianship. North Carolina Medicaid and the North Carolina Social Security Administration will have all the forms that you need in order to apply for guardianship or for benefits. The Autism Society has some good resources as well. Here's the link to find out who your Autism Resource Specialist is. We have workshops that we provide regularly throughout the year, and many of those deal with these topics. We also have webinars such as this one, which you found, and toolkits that you may find helpful. On occasion, the Autism Society staff write blogs that relate to guardianship, Medicaid, and SSI, especially with some of the changes in laws. So it's important to kind of look at those blogs and find out what is a change that's coming up that may impact your child. So this is the end of my presentation. I thank you for viewing this, and I hope it is helpful. If you have questions, please reach out to the Autism Society of North Carolina and one of the autism specialists, or to me personally, and we will be happy to help you with your issues. I hope you have a great day.